To start with, focus on health law. This is a proud presentation of the Law Office of Attorney at Law, Mr. Kenneth Haber. The moderator here is Attorney Ramesh Khurana from the Khurana Law Firm, located in Rockville, Maryland. This morning, these two attorneys will present Part 2 of the three-part series on Medicare and its developments now and in the future. Let's take a look.
Good morning. This is Ramesh Khurana, Attorney at Law. I am practicing in Maryland and have my office in Rockville. This is my great privilege to welcome Mr. Kenneth Haber, who is a very senior and experienced attorney practicing in Maryland and having his office in Maryland. Mr. Haber, welcome to our studios this morning.
Thank you very much, Ramesh.
Mr. Haber, I remember in part 1 of Medicare and its developments now and in the future, we said that there is to be a financial squeeze concerning healthcare cost. That was a very interesting session I recall, which was 2 weeks back. Now, we have seen that government has 5 major statutory tools, and I also do recall that in our last segment we did talk about the False Claims Act. Now, what are some of the other statutory tools that the government has at its disposal? Would you please describe for the benefit of the audience?
Yes, first of all, I'd like to really thank you for my being able to be here, and I'd like to elaborate on these tools. After the False Claims Act, probably one of the next most effective tools of the government is the Anti-kickback statute. It's so effective is because of the fact for those who are interested in doing wrong, they're normally going to be getting some sort of remuneration for doing wrong, so that's the kickback. You know, they're getting money back for doing the wrong. It's a remuneration. Remuneration in any sort of fashion doesn't have to be, here's $1 for giving me the patient, although that happens all the time. It could be, I'm going to pay you $1,000 to give a seminar, knowing very well that by paying you $1,000 to give a seminar, you're going to give me the patients. And all those are looked into under the anti-kickback statutes. Pharmacy manufacturers have changed their models of sales dramatically because they used to indeed have doctors give seminars, pay them money, and of course it'll be influencing them in terms of their patient flow and also in terms of other doctors who would be receiving the seminars. The anti-kickback statute is one of the key elements of the tools the government uses for criminal liability. It has fines, jail terms, and it also can result in exclusions from participating in healthcare programs. Under the False Claims Act and the civil money penalties statute can be used to enforce the anti-kickback statute. And the civil money penalty statute is an administrative statute, but it can result in $50,000 fines for each violation, as well as 3 times the amount of the remuneration, just like the Civil False Claims Act results in treble damages, but $11,000 fines for each kickback. So the civil one, administrative one, is even harder or more difficult on the doctor who's charged with it. I had one case like that where I defended somebody who had been charged administratively with the civil money penalty, and he had actually gotten the money accidentally. His office manager was new, and she had a couple bursts of billings that went out, and they were not done right. And he offered to pay the money back, but the government
it was too late.
It was too late, but that's okay because we went to the hearing and we tore up their case, and they decided to just take the money back anyways.
Oh, interesting.
Yeah,
interesting.
so we were very fortunate.
Congratulations, you were successful.
Yeah. I would say that. We were very fortunate and blessed on that one. There's regulations that protect people both from the anti-kickback statute and what's called the Stark statute, where it's self-dealing. And these regulations create protected areas of activity. They relate to bona fide areas of employment, they relate to contracts, they relate to the various areas that doctors have in their practices that they run into, and how to ensure that by compliance with these regulations in their contracts. And if you recall, we talked about vendors being areas of concern with red flags in a prior broadcast. But by having these proper these regulations properly enshrined in contracts, the doctors will be able to have protections by these safe harbors that are out there. Physicians are attractive targets of kickbacks, where people try to entice them into relationships and try to convince them that it's okay to do this or do that, when in fact it might not be. There are elaborate schemes out there that people have to try to fool physicians. They'll have quote-unquote institutes that give out propaganda, how they should bill for the devices that the physicians are buying to use on the patients, and a variety of other things that the doctors just have to be careful of so that they don't get trapped. Kickbacks are difficult for our system because of the fact they lead to overutilization, increased program costs, corruption, and unfair competition. Doctors trying to do things right are competing with doctors who are getting competition with kickbacks. It's unfair to the doctors who are doing things right. But there's a whole slew of interrelationship between the Anti-Kickback statute, the Civil Money Penalty, the False Claims Act, what's called the Stark Act, and how these are used to try to root out violations of the law, and for the unwary doctor who falls prey to unscrupulous individuals who are trying to entice them, how it can mean disaster for them.
Interesting. Ken, I appreciate telling us all these tools which are available with the government. Now, I think I would appreciate, if for the benefit of audience, if you can also talk about the physician self-referral law.
Yeah.
Because all these scenarios are so complex.
Right.
I think each physician would like to know from you.
Yeah. The physician self-referral law, also is known as the Stark law, is in fact one that's there designed to prevent people from taking advantage of the system. There's certain designated health services that are considered so sensitive that they're on the list for the Stark statute. Clinical laboratory services, physical therapy, radiology, DME supplies, prosthetics, home health services. These are all areas, and there's others that are laden with possible overabuse, overutilization that comes from people, either having bad advice or being just greedy, where they're making a prescription out for some of these things. A good example would be a DME. DME and the DME supplies, durable medical equipment. If the doctor was able to write out the DME and then have all sorts of people dispense the DME, he could just sit there with a pad in his hand and write it out. That's how come it's very, very stringently regulated how a doctor can write out DME if he's going to be supplying it. There's some real strict limitations on what a doctor can and can't do, how he can do it and how he can't do it on any of these. But it's a good example because of the fact you can just see a doctor with very expensive supplies, can write that out, indiscriminately without medical necessity, which is a key to any of these things, and then have his own people fill the prescription, and he makes a lot of money.
Thank you. Very useful information, Ken. Now, can you please also explain what is the exclusion statute?
Well, the exclusion statute is what gives the Inspector General's office authority to deny people participation in the Medicare program for years even. I mean, it could be, so long it's beyond the person's lifetime. The fact of the matter is that if a person has violated one of the laws, the Inspector General's office can step in. They normally wait till there is an adjudication of some sort, either administratively or civilly or criminally, and use that as a basis for their decision. But they don't have to. They can and have stepped in and said that this person has done something wrong and we're going to have a hearing, and there'll be an administrative law judge, and the administrative law judge will make a decision whether this person has done wrong and not just rely upon, say, a prior conviction. This gives them the authority to say you're going to stay out for 3 years, you're going to stay out for 10 years, you're going to stay out for a lifetime. Although I do have reservations with the lifetime. But that's what the exclusion statute does, but it goes beyond the Medicare. It goes into any government health care program. It'll actually have effects in terms of employment as well. If you're excluded, you can't work for a contractor or you can't work for an employer that's doing government services. They'll keep you out from that as well.
Thank you very much, Ken. I really appreciate coming to our studios and giving us a very useful presentation on Medicare and its developments now and in the future. And it was part 2. And it was interesting to see your presentation on part 1 2 weeks back. And I appreciate, and I thank you very much again.
I thank you. I thank you very much for having me here.
Thank you.